Hello everyone, welcome to Court with Krissy. Here are 4 short court clips you probably didn't catch, but this time I'm doing it just a little differently. There's been a lot of updates lately, so if you happen to miss the first appearance, link will be in the video as well as in the description. I hope you like it. Court with Krissy is now in session.
I'll keep bringing them in and out, but I'm going to call right now out of order People versus Charles Duba. This is file number 23-6610F8.
For the record, Your Honor, Mike Roll on behalf of the people.
Larry Brown on behalf of Mr. Duba.
Thank you. So I'm calling this case out of order because I just received an ex parte request by Mr. Brown to adjourn the hearing today, and I'm not inclined to sign that until I have a record made and make sure that I hear from the prosecution. I understand, Mr. Brown, the reason why you filed the motion. My understanding is you've been in communications with the prosecutor. You had sought to adjourn this matter in advance of today. And at least as far as I had understood, again, the way this usually comes up, attorneys are talking with my staff. My staff gives me a status update. My understanding is, Mr. Rolla, you were requested to agree to an adjournment, but you declined to agree to the adjournment given the nature of the case. Is that right?
That's correct.
Yeah, the information basically that I was provided was that there was a claim that there was issues with storm damage, and then secondarily, Mr. Duba had reported that he was positive for COVID. And I think the way that it came together is once you got what you thought was confirmation of a COVID test being positive, that's when you filed your ex parte motion asking me to adjourn the sentencing hearing. Is that right, Mr. Brown?
That is correct, Your Honor. That is the basically a picture of a COVID test. That is the only information I received, so that is all that I had to send. I was supposed to get a fax from a hospital. I did not and still have not received that.
Did you have any other information for the court's consideration in relation to your motion?
No, Your Honor, other than, I mean, the damage to the home, I'm sure, is very reasonable, as many people have damages. The COVID is the only other thing that I had, so that's what I have. And I don't fault Mr. Roll. I understand the reasons he would not stipulate. The long and short of it is, I guess I just received some information that he is not going to be here. That's pretty much it.
Mr. Rolla, did you have any further information for the court's benefit?
I do not, Judge. The only issue, like I said, that as I explained to Mr. Brown, is we have the victims that are out the restitution for extended periods of time, so we didn't want to have sentencing unnecessarily adjourned. Thank you, Your Honor.
The court has extreme concerns about this case. I want to try and encapsulate all of those in a way that makes sense for further review later. Mr. Duba has 6 prior felonies, 2 prior misdemeanors, 2 prior theft offenses, has generally been involved with this case since 2023. It's an older case. We had it set for a trial with a firm date. He finally decided he was going to resolve the case by way of plea. And I recall some difficulty in getting that plea established and done. But in any event, we got it done, and the plea was taken on February 6th. I adjourned 60 days, and while I don't remember specifically why, I know that I wouldn't generally adjourn 60 days unless I found a good reason for it. However, in the interim, we've had some significant major storms in Otsego County, and I was aware of all of those. Obviously, I live in Crawford County. I was aware of those storms. I've been made more aware of it as the time has gone on, how bad the damage was. So I was not going to be surprised this week if and when I had requests to adjourn on the basis of storm damage. That being said, my concern is that the claims are just that. They're claims. They're farcical to avoid a potential prison and or long jail sentence. I'm quite sure that Mr. Duba is aware that his guidelines are 12 to 24. If he pays restitution, 12 to 30 rather. If he pays restitution in full before or on the sentencing date, it would be 12 to 24 because there would be no habitual. So I'm confident Mr. Duba understands that he's going to jail likely and or prison based upon his conduct. I also am concerned that I'm getting differing suggestions and what I view as potential excuses from Mr. Duba. First, it was a claim of storm damage. Then it was a suggestion that he has COVID. A note that the clerk's office gave me today, because apparently he called in this morning to the clerk's office as he was running late because of a flat tire. All of those appear to be made up to the court. However, I also am cognizant of the fact that if Mr. Duba has COVID, and if I put him into jail and or to the state prison system, I would be potentially endangering other people. And I'm aware that the storm damage is major in this county. So I am going to adjourn Mr. DeZuba's sentencing hearing. I'm going to require that he provides proof outside of a positive test that he attempted to provide of the fact that he has COVID at diagnosis, so that I can be sure that the things he's claimed is accurate. I'm also going to require that he provides proof of whatever damage was to his home that he's claiming that he could not make it to court, and that he provides proof of any damage to his tire. To the extent he doesn't provide proof of a positive COVID diagnosis, of damage to his home, or of damage to his car wheel, I'm going to view all of those circumstances negatively as it applies to him, because it will confirm my suspicion, my feeling that he's probably not being honest about those things happening. To the extent he shows all of those things, a positive COVID diagnosis, that there was damage to his home, and or that he had damage to his vehicle tire, I will understand and be more understanding of the need to adjourn today. I'll also allow, of course, the attorneys to follow up on that information as well in whatever form they think is necessary. Given that record and the court's decision, Mr. Brown, did you want to make a further record?
No, Your Honor. I will make sure I contact and let him know exactly what he needs to do.
Mr. Rolla, any further record that people would want to create?
Yes, very briefly, pursuant to the holding in People versus Sowers, should the defendant not be able to provide written documentation to verify these reasons why his sentencing is being adjourned, the people would then be, of course, arguing that 10 points would be added to OV-19, because this is interfering with the administration of justice, in addition to any other actions the court would want to take in regards to sentencing. I make that statement now so the defense is very clear where the prosecution is coming from, because again, this matter's been going on for a long time, as the court's noticed, and the victims have had justice delayed a long time. Thank you, Your Honor.
The court takes note of that. However, again, to the extent you don't have written information, at least 5 days before the sentencing hearing of all of those things, I would suggest that you file a written request and include the citation to the case. While I'm generally familiar with OV-19, I don't recognize off the top of my head the case you just cited. So just provide me the cite in writing. It'll also be provided to the defense, and then I can research that case as well.
I can do that, Judge. Well, I've already done it before. I'll have to just recopy a document. Thank you.
All right, thank you.
Dusty.
Did we remove Sonnenberg?
Oh, no, we did not, but it doesn't look like he has an attorney yet.
I just wanted to make sure we didn't skip a 1:30.
Judge, it sounded like maybe I could help.
I completely understand 1000%, Mr. Harrington. He just needs to save some money. It's just,
I would do it for free.
I know you would. I 100, and I appreciate that, and I appreciate you for doing that. I'm trying to give him time.
Sure.
All right.
Not a problem.
I'm going to do Mr. Sonnenberg's case first. It's not your case. You can still be seated right there. That's totally fine. We will go on the record in the matter 24 CF 252, State of Wisconsin versus Andrew Sonnenberg. The state appears through District Attorney Kevin Schmidt in person. Mr. Sonnenberg appears by video conferencing in custody in Burnett County Jail. We're set today in this matter for a status conference. Mr. Sonnenberg, I received a report from the SPD, the State Public Defender's Office today, actually, which indicates that they have attempted to contact a voluminous amount of attorneys to be able to take your case. They have not been able to locate any attorney that does not yet have, or that can yet take this case, that may not have a conflict or is overloaded with cases, etc. I don't know exactly why, but they have not yet been able to locate an attorney to take your case. I can't recall exactly where we are in the process of your case. I believe we had the prelim, we had the waiver of preliminary hearing, and we're at a status. So what I'm going to do, Mr. Sonnenberg, is I'm going to have the clerks send a letter to the public defender's office just to try and see if they can speed it along a little bit. I'm not sure if you're aware, but Gabriel Pollack, who was the lead attorney of the SPD, he has now taken a different job elsewhere. And so I don't know if that has anything to do with it, but I strongly encourage you to contact the public defender's office and inquire yourself into getting an attorney appointed to you. Okay. All right. So what I'm going to do is I need to set the matter for another status on your week, Mr. Schmidt, or on your week. Okay.
Excuse me, Your Honor.
Yes, sir.
Do we still do the speedy trial?
You cannot until you get an attorney appointed to you, and hopefully one's going to be appointed to you very soon. And that's why I'm telling you, please contact the public defender's office, give them a call today, give them a call tomorrow, and see what's taking so long to get an attorney appointed, okay?
Okay, thank you, Your Honor.
What I'm going to do is schedule it for 9 o'clock. Oh, wait, because I have a hearing there. I'm going to schedule it for 9:30 on April 10th, 9:30 on April 10th. Please contact them as quickly as you can. And if you don't get a hold of them, contact them again the next day. Try and stay on top of it, okay? Because they're very busy right now.
Okay, Your Honor, thank you.
All right, thank you. We are adjourned.
Thank you. Good.
All right. You must be Crystal Church there at the Greenwood County Jail.
Yes.
All right, we'll go on the record. Case is entitled State of Kansas versus Crystal Dawn Church, case number 25 CR 10. The state appears by Darren Deviney. Miss Church appears in custody from the Greenwood County Jail. Excuse me. All right, Miss Church, it looks like there's been several attempts made to get you served with a summons for a pending case out of Butler County. I'm going to go over those charges with you. There are 2 counts, both alleged to have occurred on August the 2nd, 2024 in Butler County, Kansas. Count 1 is an allegation of possession of methamphetamine, a level 5 drug felony. Count 2 is an allegation of possession of paraphernalia for use, a Class B non-person misdemeanor. Do you understand what you've been charged with? All right, you'll need to answer audibly, please.
Yes.
Okay. There is a felony involved, so you won't be asked to enter a plea today. Your case has been assigned to Judge Satterfield. Your next hearing on this case is April the 28th at 2:30 on the preliminary hearing control docket. Is there somebody there to write that date down for you, or do you have something to write with?
Yes, she's writing it down.
Okay, April 28th at 2:30 p.m., Judge Satterfield by Zoom. Can you afford to hire an attorney to represent you?
No.
Do you wish
Not
to
yet.
apply for a court-appointed attorney?
Yes, please.
Okay, are you employed?
No,
Okay, how long has it been since you've worked?
it's been years.
Okay, how do you get by?
I mean, I've had jobs here and there, but I wasn't getting by very well. Actually, my electricity was getting shut off, my water was shut off. I was fixing to move in with my brother, and he was going to help me get on my feet again.
All right, I'll appoint James Watts to represent you. I don't know if they have his contact information there, but I'll provide it if they don't.
You have, okay, they don't have it, they said.
Okay, 316. All right, Mr. Deviney, what's the state's recommendation for bond?
Your Honor, the circumstances of this case where she's getting booked into the Butler County Jail on a Montgomery County warrant. Apparently it's got some kind of hold or something in Greenwood, maybe it would appear, but she was found in possession of the drugs when she was being booked in on another warrant. So we got a couple different jurisdictions here where we've got cases that need to get resolved. It sounds like I think that a $7,500 cash or surety would be appropriate in this case.
Ms. Church, is there anything you'd like to say regarding the bond?
No, sir. No, sir.
All right, I'll set bond at $7,500 cash or surety. As a condition of bond, you're not to possess or use alcohol or illegal drugs.
Yes.
All right, where do you, if you're not incarcerated, where do you live?
I live in Longton, Kansas.
Longton?
Yeah.
Okay. All right, when you bond out,
It'd be a very good idea for you to contact Mr. Watts's office to let them know how to get a hold of you.
Yes, Your Honor.
Okay, Mr. Devaney, anything else we need to do on this case?
No, Your Honor.
Okay, do you have any questions, Ms. Church?
No, Your Honor.
Okay, thank you, the Greenwood County Jail, for getting her here.
Yes, Your Honor. And just make sure that court date was April 28th at 2:30.
That's correct.
Thank you.
All right, thank you. We'll be in recess. Have a good weekend.
You too.
I have a copy of that, all that we wrote down.
Circuit Court because the counterclaim which was filed asserted claims that exceeded the jurisdictional limit. As each of you may know, the limit for a district court action in the state of Michigan is $25,000 or less in claimed damages. And generally speaking, the amount of a claim is what dictates which court it gets filed in. Because the case was originally filed in district court and the counter complaint seems damages above that, that means that the case then gets reassigned to the circuit court where I'm the presiding judge that's been assigned it. So I set aside today for a pretrial. In general, a pretrial is for me to meet the parties and for the parties to meet me. And then I generally set out dates for things of things that need to take place. For example, when attorneys are involved, often the attorneys want time for what they call discovery. Discovery broadly is the opportunity for each of you to learn about the complaint that was made or the counter complaint that was made. So you can seek discovery in writing, you can do depositions, you can do things like that. And you can also then ask for time just to prepare your cases for ultimate decisions. I also generally, in all civil cases, have orders for facilitation and or mediation, where I order the cases to be tried to be resolved in front of an impartial mediator. Obviously, there's no requirement that you mediate or find a resolution, but it's generally helpful. Number one, it's helpful to me because it helps the parties narrow the issues. And number two, it often does lead to success in people deciding to settle the matter on their own terms rather than having a court-imposed terms. But the first and foremost question I had for both of you, other than that general background, is whether or not you intend on representing yourselves, or if you're intending to hire counsel. It does not matter to me, but it matters in terms of how I schedule things. So Ms. Green, do you know whether or not you're planning on hiring counsel or whether or not you're going to represent yourself?
I'm going to represent myself, Your Honor.
Ms. Barkley, do you know whether or not you're going to hire counsel or represent yourself?
Represent myself. Thank you.
So then each one of you, and that's fine, you're obviously entitled to represent yourselves. Each one of you needs to be aware that whether or not you're representing yourself, I expect and require that all of the things that you do is you meet your burdens. And so where you make a complaint and make a claim for damages, you must submit sufficient evidence in order to convince me that you should be able to get that. And if you don't do that, you're not going to be able to prevail either on an initial complaint or a counter complaint or either. And so generally speaking, I can't tell you how to do that, but I can only tell you that you will be bound by the rules of evidence, just like an attorney is, and you'll be bound by all of the rules of procedure, meaning when and if we get to a trial in this case, the way that you present evidence is limited, and I will have to consider only that evidence which is brought in correctly. And so you may wish to consult with an attorney if you don't know the general procedure. Again, I'm going to hold you each to that procedure. That's my requirement. In terms of background, Ms. Green, in order to get ready for your case to be presented and or to defend against the counter complaint, do you need time for discovery? For example, to take depositions of witnesses and things like that?
No, Your Honor.
How about you?
I have one witness. I'm not sure how to go about submitting that.
But I'm not sure the question you're asking, so I can't really answer it.
I thought you asked if I had any witnesses. I have one witness.
No, what I asked is whether or not you needed time, and I speak quickly. Sometimes I assume things and I shouldn't, but I asked if you had a specific time that you needed to, for example, take depositions, if you were planning on submitting written interrogatories or requests to produce to the other side. In other words, did you need specific amount of time to prepare your case for court, or do you otherwise have it ready to go?
I have it ready to go.
All right, in terms of witnesses, once we get to the point of scheduling the case for trial, I'll generally ask both of you the types of witnesses and how long you think their testimony is going to take, because what I have to do ultimately is set aside the time that we think we're going to need for each one of you to be able to put on your proofs and then me to make findings. So when we get to that step down the road, I'll just ask you both generally, who are you planning on calling? And how long do you think the testimony is going to take? That way I can schedule a case accordingly. Is this a case, Ms. Green, where you have made a request or a demand for a jury trial?
I'm sorry, can you repeat that?
Is this a case that in your complaint you have made a request for or a demand for a jury trial?
I'm ready to go. I don't need it.
You're
No,
not
I don't
understanding
need
my question, and that's understandable. There's two different types of trials that take place under Michigan law. One is called a bench trial. A bench trial is where I, as the judge, determine what I believe to be the equitable or fair way to decide the case. I decide what witnesses I believe and whether or not the proof has been shown for whatever you're claiming. The other type of trial is a jury trial. A jury trial right is not guaranteed. It depends upon the claim. It's up to the parties to make a demand for a jury trial, number one, if they want a jury trial, and then number two, for the court to determine whether or not the claims are subject to a jury trial demand if it is made. So my question is, were you asking for a jury trial in this case? I think you said no, but your audio kind of broke up.
Yes, no, Your Honor.
Okay. And Ms. Barkley, in your counter complaint, did you make any sort of a specific demand for a jury trial?
No, thank you, Your Honor.
Okay, then what I really need to do then is just understand, I'm going to refer the case to a mediation. I generally would consider, if it was an advanced type of action where there's a lot of different factual scenarios, sometimes I would consider ordering a case to an attorney mediator, because attorneys would generally have a better idea of how to potentially help the parties see the other side and see if there's a way to resolve the case. However, attorneys mediators charge attorneys fees, and so they're somewhat more expensive. On the other hand, I have heard from some litigants and some parties that the bigger dollar amounts that are claimed or counter complaint, you might be more effective at a mediation if you had somebody that's skilled in knowledge and has knowledge of the law that's applicable to each of the claims and or counter complaints. So to me, it doesn't necessarily matter. It really comes down to whether or not the two of you think having an attorney mediator would benefit you, or whether you're not interested in having that cost associated with having an attorney mediator. So Ms. Green, do you have any opinion on that?
Your Honor, I do. I had spent $300 starting a formal TICA complaint with TICA Cat Association. I had revoked breeding rights. I had spent quite amount of money starting small claims procedures, and realized that she had a litter of cats, my cats, unpaid for on the ground, and that I would be able to just settle out of court with her. She agreed to it.
Is the long answer, Ms. Green, that you don't want to spend money on an attorney mediator?
Well, no, it's not spending the money. I'm not even asking for money. I'm asking for the cats back. I am not asking for any money. I just want the cats back. And the problem is that I tried to resolve this out of court with her, and it backfired on me. She was not cooperating in any way, shape, or form.
All right. And Ms. Barkley, do you have an opinion on whether or not having an attorney assist with mediation would be a better idea, or just have a qualified mediator who's not an attorney be able to assist with that mediation instead? And again, generally speaking, the non-attorney mediators are significantly cheaper.
I think a non-attorney mediator can be able to figure this out and navigate it very well.
Okay. Well, what I'm going to order then, in consultation with both of what I've heard from each of you, is what we call community dispute resolution. So the 46th Circuit, which includes this county, Otsego, Crawford, and Kalkaska counties, uses community dispute resolution services, otherwise known as community mediation services. So they are all trained community mediators, and so that means they have to go through 40 hours of training to become a mediator. They are very successful, and their success rate in helping parties resolve their cases is very high. It doesn't mean there's going to be success in this case, but I am certainly going to have the parties give it a try. Again, it will be beneficial to me because at least we'll put the two of you in a room with a mediator where the mediator can hear each of your versions and see if there's any middle ground that might be able to assist. If not, again, the benefit to the court is it will narrow the issues for me. I'll have you back in front of me then again for a further discussion if the case is not resolved. Generally speaking, once I refer the case to mediation, you'll get a call. Each of you will get a call within a couple of weeks. That might be a little bit delayed right now. I don't know where each of you reside, but in Otsego County right now, the circumstances are very bad. with the ice storm that we've had. And so all of our systems are down. We have court running here in the circuit court, but even our district court is not even up and having power right now. So I say that only to just be aware, if there's a delay, that's likely why. It's because community mediation services may still be out of power as well. But that's changing quickly and generally for the better. Do you have any questions, Ms. Green, now that we're here today?
No, I don't, Your Honor. Thank you.
Do you, Ms. Barkley?
Yes, I do. When we go in front of the mediator, is it in person or over Zoom? And will they have access to the folders that I submitted to you guys?
Good question. I don't know whether or not it's all in Zoom, via Zoom or in person, I think, but I'm not sure. You can certainly ask mediation when they call. I think they're generally conducting the hearings via Zoom unless the parties agree to do it in person. So I think that's how they're doing it, but definitely double check with them. To me, it doesn't matter if either one of you wants to appear via Zoom or would prefer to appear in person. It doesn't matter to me how you go about a mediation. As to whether or not they will have anything in the court file, they will not. The court file is the court file, and so anything that you want to present or need to present to the mediators, bring a separate copy so that the mediator can have a copy of it if you think they need it.
I have like 3,000 papers I submitted to you, all outlined with facts, so nothing gets tripped up. That would take a lot of time for me to make a fourth folder.
Well, if you want them to be able to have it, that's the only option, because the court doesn't release the court file. The court file is the court file. You filed it with the court file, so the court has access to it. We don't release it from court custody and jurisdiction after that happens for various reasons, including if this case goes up on appeal, the higher courts need to be able to have that same record. So we don't release court files after they're filed. If you need to get copies and that's too difficult to do, so be it. You're going to have to do without those when you go to mediation. But it would seem to me that if there's a benefit to having the materials, you should have them. And that's the only thing I can tell you. We don't make copies of them. We will allow you to make copies of them, but we're not going to release them to anyone, even the mediators, because of court records.
Okay.
Do you have any additional questions?
No, thank you.
Ms. Green, any questions given me of that?
No, Your Honor. Thank you.
So I'm going to set what I call a status conference in about 45 days. Hopefully that will give the two of you time to get into mediation to see if you can make any type of headway. It will also then allow us all to report back in about 45 days. If you haven't settled the case at mediation, or if there's delays, we can talk about that. And if the case is ready to simply set for a day of trial, where I take testimony from each of you and make a finding, we can do that if we need to. There'll be several other discussions and requirements that will be in place before trial, but we'll have those in about 45 days. Thank you both, and we'll see you at the next hearing. You'll get a notice in the mail. Take care.